video, we'll be doing some practice questions based upon the sections of the rules that our course has already covered. We're going to practice these questions in the exact same way, using the exact same approach as we did for the first set of practice questions. So let's look at question number 1. The facts tell us that 3 women were charged with armed robbery of a liquor store. 2 of the 3 women met together with an attorney. The 2 women asked the attorney to represent them in the criminal matter. The attorney decided to talk to each woman alone prior to agreeing to representing them jointly. The attorney was told by both women individually that the 3rd woman was the guilty party. Both women explained to the attorney that the 3rd woman said she needed to grab something to drink from the liquor store and that she robbed the cashier while they waited outside. Both women stated that they had no idea that the woman intended to rob the liquor store. After interviewing each woman separately, the attorney agreed to represent them both jointly. Shortly before trial, one of the women that the attorney represented decided that she wanted to take a plea deal offered by prosecution and testify against both of the other women. It is proper for the attorney to do which of the following? So just like we did last time, the first step after you've read the facts and the call to question is try to articulate the rule that's being tested. And then we'll apply the rule to the facts and try to reach a conclusion on our own. So this question is testing conflicts of interest, specifically current client conflicts. Why? Because this lawyer is now technically faced with the issue of one client turning on the other. One client now wants to take a plea deal and as a result testify against the other women, which of course the lawyer is representing one. So this is a problem, hence current client conflict. So what does the rule say about current client conflicts? Well, it specifically says that you have a conflict if one, representation of one client is directly adverse to another client. So that's one way in which we see current client conflicts. Or if there's a significant risk that the representation of one client will be materially limited by the lawyer's responsibility to another client, a former client, a third person, or the lawyer's own personal interests. So just to stop there, here we very clearly have a current client conflict because the lawyer's representation of one client will be directly adverse to another. The clients are against each other, essentially. So does the rule say anything about the lawyer's ability to move forward when he or she has a current client conflict? Well, the rules say you can move forward if you've met the following 4 requirements. The first requirement is that the lawyer must reasonably believe that they can provide competent and diligent representation to each of those affected clients. And 2, this representation is not prohibited by law. And 3, the representation does not involve an assertion of a claim by one client against another client in being represented by that lawyer in the same litigation or other proceeding before a tribunal. And 4, each client gives their informed consent confirmed in writing. So can this lawyer get around his current client conflict based upon the facts provided? And the answer has to be no, because one of the requirements for a lawyer to move forward with a current client conflict is that he's not representing 2 people in the same proceeding or same action that are directly adverse to one another. And here that's exactly what would be going on. He would be representing one of the women who is now taking a plea deal, testifying for prosecution, and simultaneously representing a defendant, claiming they didn't commit the crime. So he's kind of on both sides of this transaction, so to speak, which is a problem, and we can't consent to that type of current client conflict. So now that we know that, let's remind ourselves about what the call of the question states. It says, is it proper for the attorney to do which of the following? So this is a situation where I would recommend that at this point, you read each answer choice and just evaluate it. Does that fit based upon what we just said pursuant to the rule that's at issue? So answer choice A says, ask the court for permission to withdraw from representing both women because the interests of the women are directly adverse to one another. So A looks pretty good. It illustrates the point that we have this current client conflict, and this is not a consentable client conflict because of the parties being directly adverse. So let's hold on to A and evaluate our other choices. B says, get permission to withdraw from the court as the attorney for the woman who wants to take the plea deal and continue to represent the woman who does not want the plea deal after getting the woman who wants the plea deal to consent to the attorney withdrawing. The attorney will also need to get informed consent in writing from the woman who does not want the plea deal in order to continue representation. So we know B is wrong because we can't fix this type of conflict of interest by the attorney just withdrawing on one side. That doesn't work here. We've learned, based upon the rule, that the lawyer just needs to be done. He can't move forward and represent either client here. So B doesn't really get us to the outcome we want. Let's evaluate C. Get permission to withdraw from the court as the attorney for the woman who does not want to take the plea deal and continue to represent the woman who wants the plea deal after getting the woman who does not want the plea deal to consent to the attorney withdrawing. The attorney will also need to get informed consent in writing from the woman who wants the plea deal in order to continue representation. So this is not a great answer either because it's essentially like the opposite of what B just said. And we've learned B doesn't work because the lawyer just needs to withdraw from representing both clients. And therefore, if B's wrong, it makes C wrong too. Just a little tip, be on the lookout for answer choices like this where they are basically identical but flip-flopped or reversed to one another. That's usually an indicator that they're both wrong. And then finally, answer choice D, continue to represent both women after they give their informed consent in writing. So that doesn't work because, as we noted, this is not a consentable client conflict, so he can't move forward even with consent. So D is not the best answer. So let's move on to question 2. Let's handle it in the same way. Turning to the facts first. An attorney represented a man for a breach of contract claim against the man's former employer. The attorney was able to obtain a settlement for the man without having to file suit. The employer paid the man in a lump sum, and the man paid the attorney his fee. The attorney did not do any other work for the man. About 6 months after the settlement with the employer, an attorney who represented the man's ex-wife called the lawyer to inquire about the previous settlement, as the man was behind on child support. The attorney did not disclose any information to the ex-wife's attorney and instead called his client to explain the situation. The client told the attorney not to provide any information to his ex-wife's attorney. Is it proper for the attorney to furnish the information to the ex-wife's attorney? So stopping there, asking ourselves what rule is being tested. Here, what's happening is the ex-wife's lawyer is calling the man's lawyer and saying, I want information about this man's case. In other words, he wants confidential information. So this question is testing a lawyer's duty of confidentiality. So what does the rule specifically say? Well, the rule tells us that a lawyer shall not, strong language, reveal information relating to the representation of a client unless the client gives informed consent or disclosures impliedly authorized to carry out that representation, or 3, there's an exception that's applicable. So let's stop there. Here the facts make it very clear this man did not give consent to his lawyer disclosing this information to his ex-wife's lawyer. So consent here is not an option. So then you have to ask yourself, is this a situation where there's essentially like implied consent, where the disclosure is impliedly authorized by virtue of the lawyer's need to carry out his representation? And the answer is, again, no. And I can state that very confidently because here we are told that the lawyer is no longer working for the man. This is a former client. There's nothing this lawyer needs to do to carry out the representation of the man because, again, that matter he handled for the man is over. So this is not a situation where disclosure is impliedly authorized to carry out representation because there is no current representation. So that leaves you with having to go through the exceptions to our duty of confidentiality, and there are 6. So let's talk about those 6 to see if any are applicable. The first is that a lawyer may reveal, so it's permissive, not mandatory, may reveal confidential information to prevent reasonably certain death or bodily harm, Here, that's not going on. I don't have any situation talking about someone dying or being hurt. 2, the lawyer can reveal information to secure ethical advice. Here, I don't see any sort of facts supporting an ethical dilemma. The third exception is to detect conflicts of interest. And here, I do not have any facts that support the lawyer revealing this information to detect a conflict of interest. The fourth exception is to comply with a law or court order. And again, no facts here support this exception. There's not any facts that indicate the lawyer is being ordered to reveal information. The fifth exception is the lawyer can reveal information to defend himself or herself in a controversy with the client, or if the lawyer finds himself being charged or sued based on actions taken on behalf of the client. Here, we don't have any facts that support that scenario. And the sixth and final exception that would allow the lawyer to reveal this confidential information is to prevent your client from committing a crime or fraud that's reasonably certain to result in a substantial injury to financial interests or property belonging to another person, and in furtherance of which the client is using or has used the lawyer's services. And this exception also doesn't apply because currently the facts tell us that there is not an ongoing relationship between this attorney and the man. Again, the man's legal issue is over. Additionally, we're not told that this lawyer was used in any way to help this man duck his, responsibilities relating to his children. The child support issues were not an issue when this lawyer represented the man. So this sixth exception doesn't apply, which means the lawyer cannot reveal this information to the ex-wife's lawyer. So always revisit that call to question. Is it proper for the attorney to furnish information to the ex-wife's attorney? You're going to be looking for a no answer that basically illustrates something along the lines of the duty of confidentiality does not allow the lawyer to reveal this because he doesn't have consent. This is not a situation about implied disclosure, and none of the exceptions apply. So let's take it from the top and evaluate A. A says yes, because the attorney may reasonably believe that disclosing this information would prevent the client from committing a crime. So A is wrong. First of all, we're looking for a no answer, and it's a yes answer. But A is also wrong because this is not exactly what our exception says. Remember what that sixth exception is that we just talked about. It's a situation where the client's used the services of the lawyer or is using the services of the lawyer to commit this crime or fraud that's reasonably certain to occur. Here, there are no facts indicating he has used or is using the lawyer to commit a crime or fraud. So A is wrong. B says yes, because disclosure is necessary to carry out the representation of the client. And B is wrong because it's all about timing. Here, the lawyer's representation of the man is over. So there is no continued representation. So there's no reason to make this disclosure. C says no, because the client told the attorney not to provide the information. So C looks pretty good. It speaks directly to one of the issues of consent, which the lawyer doesn't have. So let's hold on to C. And let's double check D. D says no, because the attorney did not reasonably believe that disclosure of this information would prevent reasonably certain death or substantial bodily harm. So D is wrong, because while it's a no answer, I read it to almost say that this is like the only instance in which you could reveal confidential information, and that's wrong. It's only one of the 6 exceptions, which of course is not applicable. So that makes answer choice C the best answer. Turning to question 3. The facts state that an attorney was representing a plaintiff, a popular musician, against a famous actor in a divorce action. Since both the plaintiff and the defendant were famous, the lawsuit received a lot of publicity. The attorney and the plaintiff had reached an agreed-upon hourly rate at the beginning of representation, and the attorney was billing the plaintiff throughout the case. Recently, during a conversation between plaintiff and the attorney, the plaintiff explained that she was running out of money paying the attorney. Plaintiff offered to give attorney the media rights to any and all books, movies, or television programs based on the litigation as payment for representation. The attorney responded by telling the plaintiff to consult a different attorney to make sure the offer was in her best interests and that they could discuss the arrangement in a couple of days. The plaintiff sought independent legal advice on the issue and assigned all media rights to the attorney a few weeks later. The attorney had the plaintiff give informed consent in writing, upon agreement to assign attorney the media rights. Is the attorney subject to discipline if he agrees to plaintiff's offer? So here the rule that's being tested is another conflicts of interest rule. And more specifically, this rule tells us that prior to the conclusion of the representation of a client, a lawyer shall not make or negotiate any sort of agreement that gives the lawyer literary or media rights to any sort of portrayal or action based in substantial part upon the representation of that client. And here the facts make it really clear. This client is running out of money and can't kind of stay up to date on her bills with this lawyer. So she's willing to assign her rights to any sort of like media portrayal later. And what's problematic is that this lawsuit, the divorce, is ongoing. And the rule specifically states that if it's ongoing, this type of arrangement is not allowed. So that means the lawyer can't enter into this, even if it's in assigned writing, even if another lawyer is involved looking out for this client's best interest, it doesn't matter. This is a prohibited transaction. So the call to question says, is the attorney subject to discipline if he agrees to plaintiff's offer? And the answer is going to be yes, because according to the rule, if the matter is ongoing, these types of agreements are prohibited. So let's look at our answer choices and evaluate them in order. Answer choice A says yes, because this fee structure would likely give the attorney a fee that's not considered reasonable. So A kind of misses the point. While fee agreements need to be reasonable, true, we aren't entirely sure what type of money this would generate for the lawyer, but more importantly, we are positive that this type of agreement is generally prohibited. So A misses the point, A is wrong. B says yes, because the attorney is still representing the plaintiff as the matter is ongoing. Well, B looks great. It speaks directly to the issue that appears to be tested here. So let's hold on to B. C says no, because the client gave informed consent in writing to the arrangement or to the agreement. Well, C is wrong. It doesn't matter if the client consented to this. This is like a prohibited transaction. This is not consentable. So C is wrong. And D says no, because the attorney told the plaintiff to seek independent legal advice and then waited a couple of days before entering into the agreement. And D, much like C, is wrong because this is not consentable. Getting another lawyer involved or getting your client to sign this type of agreement doesn't make it okay. It's just generally prohibited, making B the best answer to this question.